Good evening, everybody. Happy Friday. Welcome in. Welcome in. Needed to start a little bit later tonight. Hope you all understand. Sure you do. But welcome in. Welcome in. I do have comments off while I read through the transcripts tonight, but I will do a Q&A immediately following the reading for tonight. So welcome in. Now I will be reading again through part 2 of Miss Stormy Daniels's transcripts. I have redacted multiple words just to make sure that this is rated PG for everybody. And I've also made sure to move any concepts either also that may have made a problem. So in other words, this is, I wouldn't say a family show, but it's definitely should be okay for everyone. I do have, again, audience controls at 18 and over. With the redacted words, we should be well within the community guidelines here for TikTok for reading these, so shouldn't be any problem. But welcome in, welcome in. Again, I will be doing a Q&A session immediately following reading the transcripts. Now, I'm hoping to be able to get through another 150 pages tonight. That will take us then through the beginning of her cross-examination, but we'll finish her first day of testifying. So with that, I think we'll only need to do one more live then, finishing up her cross-examination, and then we will have all of her testimony gone through then through the transcripts. So hopefully that's kind of what my plan is at this point. So just as a friendly reminder here, we have the people of New York versus Mr. Trump. We have 34 counts of false business records information, and the reason behind it was for an illegal purpose. That illegal purpose was to he had a story to tell, and in order to pay or buy that story, they did pay her a huge amount of money, and that money was documented in a way that was improper under campaign laws and business laws in New York. And so that's why we have 34 counts here of Class E felons laws in New York. And so that's why we have 34 counts here of Class E felony. So that's kind of the reminder, everyone, of what's going on in this case. We did have some testimony today. Court ended early today, and we had multiple people come on in order to allow for certain kinds of evidence to come in. So there were some authentication stipulations that Mr. Trump refused to stipulate to, which is his right as the defendant. And so because of that, they needed multiple witnesses in order to get different pieces of evidence to come in. So there were lots of different witnesses today with that, but they were able to, thank you, James, they were able to end trial early today. So with that, again, I will try to get through about 125, 150 pages tonight of the transcripts. I do have comments off just so that I can focus on reading the transcripts, and we also are set at an 18 plus tonight. Probably the biggest of the testimony I have already read through, but there still are some words and concepts in here that may be troubling to some. So I wanted to make sure that I've got my live set to an appropriate age. So here we go again. We have Ms. Daniels, Judge Mershon or Justice Mershon here, and we will finish up her direct tonight and then get into the cross-examination. So that is my goal. I will also be reading the sidebars. We do have a motion for mistrial, the first one that was made, and they did argue that at the bench, and so I will be reading through that as well to give everyone an idea of what the mistrial questions were. Just to remind everyone also that the blue is for the state of New York, the pink highlighted is for the court, anything in yellow is a court officer or anyone that's a court staff, and then orange we have as the defendant. Oh, thank you, Kristen. and green will be Miss Daniels. Now, I won't be changing voices tonight because I don't think it's necessary in order for you to be able to follow along with her testimony. So with that, I will go ahead and get started. For those of you who were with me last night, I will have that ready. I'm planning to post yesterday's live tonight on my Tube of You. I have done Mr. Pecker's testimony. All three pieces, I believe, all three lives have been posted on Mr. Pecker's testimony. That's it for testimony that I've read. So I should be up to date regarding reading transcripts here. So Miss Daniels, as said, will be coming up next for anyone who is watching on my Tube of You channel, which is the same as my TikTok handle here. So again, I would remind you I am just a one-woman show here, so I do need a little bit of time to get everything posted everywhere. So please be patient. All right, let's go ahead and jump on in. Now, when last we met, everyone, we went ahead and had a break. So the last piece that I had read to you last night was page 2664. Up at the right-hand corner, you'll see the page I'm on. And what I am reading is here, the proceedings. Now, the court did break here, and that was where we last left off. So I will start with the court going into a bit of a sidebar discussing some of the testimony that Miss Daniels did give that I read through in the transcripts last night. So again, this has been redacted, so I'll go ahead and get started here. Is there anything else that we need to discuss at this time? No, Your Honor, no. I'm going to hand up a copy of the stipulation that was entered into evidence the other day to be marked as court exhibit. Thank you. Enjoy your lunch. And then this is where we stopped last night, and we will pick up here tonight. Afternoon session. Good afternoon. Thank you, Your Honor. If I could have a second, Mr. Blanche, pardon me. If I could just have 1 second, Mr. Blanche. Oh, Your Honor, I'm sorry. Just for the record, my chambers reached out to the people in defense counsel to ask if defense counsel wanted a limiting instruction on the encounter that took place in the parking lot where Miss Daniels claims that someone had threatened her. I will not give a limiting instruction unless the defense requests it. And even then, I would ask the two sides to see if you can agree on a proposed limiting instruction. I realize you haven't had a lot of time to work on that, but I also received your email that you wanted to make an application. Please go ahead. Yes, Your Honor, thank you. We move for a mistrial based on the testimony this morning. Your Honor, there have been a couple of different reasons, but what's clear is that the court set guardrails for this testimony, and the guardrails by this witness answering questions from the government were just thrown to the side, and there is no way to unring the bell in our view, and that the testimony that came in was so unduly and inappropriately prejudicial to President Trump and the actual charges that are at issue in this case that there is no remedy that we can fashion or we believe the court can fashion to unring the bell. I mean, the testimony, Your Honor, about the alleged incident back in 2006, a lot of the testimony that this witness talked about today is way different than the story that she was peddling in 2016, Your Honor, which is from my understanding of what the ADA said this morning. The only reason why this evidence is even admissible, right, is to talk about the information that was supposedly kept from the voters in 2016. There was testimony today about being blacked out, about not wearing protection, which was after there was testimony from her employer that you had to wear protection, that there was always a protection worn. The height of the two individuals, the fact that the things like spacing in the room, the fact that there was a bodyguard outside the room, the power dynamics. She testified. The question was, do you want out of the trailer park? And all of this has nothing to do with this case. And it's extraordinarily prejudicial, and something that is the only reason why the government asked those questions, aside from pure embarrassment, is to inflame this jury, to not look at the evidence that matters, but to just hear from this witness. And on top of that, Your Honor, even after the incident, there was testimony about a second alleged act advanced sometimes later on, totally irrelevant to this case, and there is no reason that should have been elicited, Your Honor. Again, we don't even know that that's coming because we don't get notes of what this witness has said in prep. That last one we got from last year, Your Honor. She testified that there was communications with President Trump after she had thought something bad was going to happen, and that she was worried about not being safe. And then she repeatedly testified about purported alleged meetings with President Trump. And with every single one, she qualified that it was in an open place, in a public place. What's the jury to do with that? And for many of those, you sustained objections to, Judge, and that is true, but it is said repeatedly, and the jury hears it. And I'm not sure that the transcript will say objection sustained by Your Honor, but it's still extraordinarily prejudicial to insert safety and safety concerns into a trial about business records. And I know Your Honor knows this, but this is exactly what President Trump was, what we raised with the court, seeking an adjournment based upon Ms. Daniels' changed testimony for years, including up to 2016, which is when she was peddling this story. She talked about a consensual encounter with President Trump that she was trying to sell. That's what Mr. Davidson talked about. That's purportedly what Mr. Cohen was told. And that's not the story we heard today. We heard a completely different story. And the reason why that matters is because of the course. We are going to cross-examine her on the fact that her story has changed. And I'm sure the government will then say we've opened the door, and then they can go ahead and ask even more questions about what she wants to say about what happened in 2006. But it's so prejudicial in a case about an NDA and whether there are false records placed on the Trump Organization's books in 2016. And I think Your Honor knew that this was an issue by setting up guard. And it is an issue, and it's not, how can you unring the bell? And we are going to cross-examine her shortly, presumably, and talk about and then elicit the fact that she denied twice. There were articles that said she denied it, that she denied that this took place. But that's not really the issue. I mean, that's going to be the cross. The issue is she has testified today about consent and danger. That's not the point of this case. That's not the point of her testimony. And that's not what she was peddling. Not what she was peddling, not the story that she was selling in 2016. And now we're here. I mean, the least of which is the fact that just over lunch, people are already reporting. Everybody is reporting that she's suggesting consent. Again, that's a new fact, and it's extraordinarily prejudicial. And the mere fact that she says there was consent after saying she blank out, doesn't remember anything, that they only had water, but she doesn't remember anything. This is the kind of testimony that makes it impossible to come back from. I mean, not even talking about the fact that we're talking about somebody who's going to go out and campaign this afternoon. And how unfair is it that environment as well? But the government must have known this was coming out. And it's just, we sit here listening to it, and we objected to it the best that we could. But, this has nothing to do with the reason why we're here, Your Honor. And even the limited fact that she signed the NDA, the limited fact that she was selling this story over the years, including at the time of the election, that's not what we heard today. That's not how the evidence came in from this witness. Of course, Your Honor cut her off several times, but there was so much, and we haven't looked at the transcript to give all the examples, and we are happy to do so if that's helpful. But how can we come back from this in a way that's fair to President Trump and in a way to make sure that this process stays exactly where it should be, which is about whether there are false records on the Trump Organization's books and put on in 2017? So we believe, regrettably, that there should be a mistrial, and that to the extent that there is another trial, this witness is either excluded or that her testimony is extremely limited to the guardrails, frankly, that Your Honor set this morning. Thank you, Mr. Blanche. The people, pause for one moment, everyone. Yes, thank you, Your Honor. Again, I would just take note this was fully briefed by the defense in their motions in limine. And Your Honor did not put any guardrails on her testimony, recognizing, of course, that this completes her account. Her account completes the narrative of the events that precipitated the falsification of business records. And this story, Your Honor, her account is highly probative of the defendant's intent, his intent and his motive in paying this off and making sure that the American public did not hear this before the election. It is precisely what the defendant did not want to become public. I will say, without getting into too many details, that Mr. Blanch's resuscitation of the fact that this is entirely new is not true. I will say that, and I'm sure that he knows this, that the account and the things like the fact that a protection was not used has been out there for a very, very long time. This is not new. This is not a new account. Now, there are certain details that I told Your Honor that she remembered after the movie in 2019, and I was going to elicit that. You asked me not to, and I did not. But the other thing is, Judge, they opened the door to this. So, in the 2011 threat to her was opened on not only in their opening statement when they talked about legal fees and that she was changing, coming up with this story because she was an opportunist out to make money and that she owes Mr. Trump legal fees. So they opened the door. That's the subject of the defamation case. Second, they specifically put in an exhibit which was admitted into evidence through Keith Davidson's testimony, where they referenced this threat in 2011, saying that it was not true. And so it was incumbent upon us to bring out those details in her direct, again, to rehabilitate credibility where they attacked it, both during Keith Davidson's testimony and on opening. So, Your Honor, we are extremely mindful of not eliciting too much testimony about the actual act. We did it initially before Your Honor even asked us to carve it back. Additionally, so there were details that were left out based on the court's instructions at the bench. There were additional details that were not brought out. But Your Honor, this stating that this is an entirely new story is not accurate. And I'm certain that when they cross-examine Ms. Daniels, some of this will come out, and some of this will come out on redirect. And I know that Your Honor has mentioned that you will allow me to elicit some of it on redirect in terms of what issues came up publicly and what details were remembered at different times based on different things. But they opened the door to the threat in 2011, and now Your Honor has asked us to discuss a limiting instruction on that, and we can certainly do that. We have written one that we have written up quickly that we can discuss with defense counsel if they would like that. But Your Honor, this goes directly to her credibility, which they attacked, and while I'm sure continue to attack. They opened the door in their opening. They opened the door in Keith Davidson's testimony, and these are not all new details. But at the end of the day, Your Honor, this is what defendant was trying to hide. And in terms of the payoff in 2016 before the election, this is an exhibit, if you would, of what they were trying, what Mr. Trump wanted to make sure didn't get disclosed. We have carved back details. We have been mindful of Your Honor's decision, and we have carved it back even before them. So I don't think there's any basis for a mistrial, Your Honor. Thank you. Just briefly, Your Honor, that misses the point, a little bit of our argument. The point of our argument is that the reason why this evidence, in theory, is admissible over our objection is because these, in theory, are facts which was presented to Mr. Davidson and Mr. Cohen so that they could evaluate whether they could enter into an NDA. And supposedly, the fact that the details that were going to be kept from the American people in 2016. That's the theory for this evidence coming in. The problem is that isn't what came in. And so what came in is this extraordinarily prejudicial testimony that has changed over time. And we can't fix that except to cross-examine her. But it has nothing to do with this case. The voters decided in 2016. The people are going to make a lot of that in their summation, I expect. And Judge, I don't think anybody can listen to what that witness said and think that that has anything to do with the charged conduct. And it's the kind of testimony that's so prejudicial that you have to run. You have to run the very high risk of the jury not being able to focus on the evidence that actually does matter. Your Honor, may I just add one thing? Mr. Blanche mentioned about the threat and so on. She testified about it directly, and she was not threatened either physically or verbally by Mr. Trump. We made sure to elicit that. We made sure to say she did not say no. At the end of the day, it was the defendant who knew the details. We submit, Your Honor, he knew the details of what occurred in the room. Okay, I can rule on this. All right, as a threshold matter, Mr. Blanche, I agree that there are some things that could probably have been better left unsaid. I think that there are some areas that would have been better if the people did not go into them. In fairness to the people, I think the witness was a little difficult to control. And that's why I was permitting some leading, to give them the opportunity to try to control the witness. It was not easy. Having said that, I do not think that there were guardrails in place. I do think that the court instructed the prosecution that there were certain details that we don't need to go into. And again, I'm not dismissing what you're saying. I do think that there are some things that were better left unsaid. Having said that, I don't believe we are at the point where a mistrial is warranted. There are a few things that go along with that. I will note that where there were objections, the objections for the most part were sustained. Where there was a motion to strike testimony, for the most part, that motion was granted as well. I will also note that I was surprised that there were not more objections at various times during the testimony. And in fact, at one point, the court sua sponte objected because there was no objection coming from the defense. So when you say that, you know, the bell has been rung. The defense has to take some responsibility for that. The court has done everything that I possibly can do to protect both sides and to ensure fairness. And that's why, again, I objected on my own. Whether these are new stories or not new stories, the remedy is cross-examination. And in fact, if they are new stories, the more fodder that I will expect to see on cross-examination, if you have any. I also believe, if you want, I will give a limiting instruction regarding the incident at the parking lot in 2011. Just bear with me one moment. Your Honor, can I just object to that 1 second, Miss Necklace, please? Yes, Miss Necklace? Your Honor, I think I just wanted to be a little clearer. I did see that you on your own sustained it, but we had moved beforehand to try to limit all of this, and Your Honor had ruled that it could come in, and so I didn't want to keep saying objection. That's a very general statement, Miss Necklace. That's not accurate. If you're going to say something like that, be accurate. Well, I'm trying to be accurate. For example, I sustained a request that the people not be permitted to go into, or what was it, the Roger Ailes. Is that his name? I agreed with you that that would be extremely prejudicial, and I didn't want them to go into that. So I didn't agree with everything that you requested, but I did agree with some things that you asked. Right. And so based on that ruling is what we were following. That's why we were not standing up and objecting. And once Your Honor signaled that you thought it had gone too far, we did start objecting very consistently. But up until that point, we really felt like Your Honor had ruled at the bench and that they were allowed to do what they were doing. So I just wanted to be clear on that. Well, we have to agree to disagree on that. I think I said multiple times to you and to the prosecution that we're going into way too much detail and that we're going into much more than we needed to. It wasn't necessary. I still believe that it wasn't necessary. Having said that, though, I don't think that we have reached a point where a mistrial is in order. I believe that a limiting instruction as to that incident in 2011 will cure that issue. And I believe that you have a remedy of cross-examination. And as I said before, the more times the story has been changed, the more fodder for cross-examination that you have. So I'm going to deny your motion for a mistrial at this time. Anything else? Do you want to discuss a limiting instruction now? Can we approach? Sure. At sidebar. I'm sorry, I think we agreed on most of the language, and we can kick over that last part to you. So here, I will read my version, our version, and then I will read their version. Our version is, you've heard the testimony from Miss Daniels regarding the 2011 incident in which she testified about being threatened in a parking lot. This testimony was permitted to explain the impact this interaction may have had on the witness's state of mind, her credibility, and her willingness to publicly disclose aspects of her encounter with Mr. Trump. That's the part we agree on. Our version then says, you must not draw any inference that Mr. Trump was behind any such threats, nor may you draw any inference unfavorable to the defendant as to the result of this testimony. The version from the defense says, I instruct you that Mr. Trump has nothing to do with any threat to this witness, and you may not draw any inference unfavorable to the defendant as a result of this testimony. Your Honor, can I just interrupt? I don't like even hearing it right now. This is going too quick, honestly. I haven't really had time to think about it. Do you want to think about it? Yes, because even hearing it, it sounds like Your Honor is saying, yeah, this actually happened, and we can test it. We're going to have to cross on this. Okay, you can think about it and get it to me Thursday morning. Yes, Judge. Judge, may I have a few minutes to talk to the witness in an effort to just perhaps instruct her to be cautious about any testimony that... Is there any objection to that? No, Judge, no objection. Okay, you can take a minute to do that. Thank you. Do you want to take a picture of this? Yes, please. Sidebar concluded. Let me know when you're ready. I'm ready. As we discussed at the bench, the people submitted a proposed limiting instruction that I was also shown the additional language that defense wanted to include, and upon further discussion, we have agreed that we are going to take some more time to think about it, and you will get it back to me by Thursday morning. Yes, Your Honor. Okay. Thank you, Your Honor. Yes, Your Honor. Okay. So, with the consent of defense counsel, Ms. Hoffinger has stepped out for a minute to give some instructions to her witness and make sure that the witness stays focused on the question and just gives the answer and does not provide any unnecessary narrative. Ms. Hoffinger, have you had a chance to speak with your witness? Yes, Your Honor. All right, thank you. Let's get the witness, please. Witness entering. The witness, Stormy Daniels, enters the courtroom and resumes the witness stand. Good afternoon, Miss Daniels. Good afternoon. I remind you, you are still under oath. Let's get the jury, please. Jury entering. You may be seated. Do both parties stipulate that all jurors are present and properly seated? Yes. Yes. Good afternoon, jurors. I apologize for keeping you waiting. We will get started now. Ms. Hoffinger? Thank you, Your Honor. Good afternoon, Miss Daniels. Good afternoon. When we left off, we were discussing some of the delays in payment and in dealing with Michael Cohen and Mr. Trump. Let's put up what's in evidence, please, as People's Exhibit 282. And we can start from the email at the bottom, please. Just blow that up. Can you see who this is an email from and who this is to, Ms. Daniels? Yes. Can you read the email for us? From Keith Davidson to Michael Cohen. Michael, I've been charged by my client with forwarding the below message. We have a written settlement agreement which calls for settlement payment to be sent by the end of business this past Friday, October 14th of 2016. No payment was received. We spoke on Friday, October 14th, and you stated that funds would be wired today, October 17th of 2016. No funds have been received as of the sending of this email. My client informs me that she intends to cancel the settlement contract if no funds are received by 5 p.m. Pacific Standard Time today. Please call me if you have any questions, Keith, and then his number. And can you just read the top email, please? To Michael Cohen from Keith Davidson, please be advised that my client deems her settlement agreement canceled and void. I have no idea what that is. Ab initio, please further be advised that I no longer represent her in this or any matter. Did you authorize the cancellation of this deal at this point? Yes. And why was that? Because the funds hadn't been sent. Now, during the time that the deal was being delayed and when you canceled this and your lawyer on your behalf canceled it, did you speak to a news outlet? Yes. Was it Slate? Yes. And was Slate going to pay you for that? No. Now, at some point, did the deal with Donald Trump and the NDA get revived? Yes. Let's put up for everyone to read People's Exhibit 276 into evidence. On or around October 28th of 2016, were you given another NDA or settlement agreement and side letter agreement to sign? Yes. And is this it? Yes. And were the terms in this agreement on October 28th essentially the same terms as the earlier agreement that you had signed on October 10th of 2016? Yes, just with different dates. And so did this deal include, again, a $1 million breach liquidated damages clause? Yes. And did you sign this agreement? Yes. Okay. I'm going to start skipping through the exhibits being presented, everyone, just so I can continue on with testimony. Is this your signature? Yes. Above PP? Yes, it is. And what did you sign it as? What name did you sign? Stephanie Clifford. Did you sign your initials there? Yes. What initials did you put over PP? SD. And is that stands for what? I think that's what it is. Honestly, I don't remember. Okay, is that for Stormy Daniels? Uh-huh. And did you sign each of the pages of this agreement that way over the initials of yours? Yes. And can you take a look at page 17 of the PDF, please? Do you recognize this side letter agreement? Yes. And did you sign it there? I did. What did you sign it as? Stephanie Clifford. Do you recognize the side letter agreement here? Yes. Okay, and who is written in for Peggy Peterson in the blanks? Stephanie Gregory Clifford, aka Stormy Daniels. And for David Dennison in the third paragraph, it said Donald Trump. And is it your understanding that that's who you were signing this agreement with? Yes. And did you sign this side letter agreement? Yes. And did you sign your name above Peggy Peterson, aka Stephanie Gregory Clifford, aka Stormy Daniels? Yes. And what did you sign your name as? Stephanie Clifford. On what date did you sign that? October 28th. 2016? 2016, right. Thank you. Now, at some point after you signed this, did your attorney, Keith Davidson, receive the $130,000? Yes. And from that $130,000, did Keith Davidson and Gina Rodriguez take fees for the deal? Yes. And after they took their fees, did you end up with approximately $96,000? Approximately, yes. I would like to direct your attention now to November 4th of 2016. Do you recognize this article that came out in the Wall Street Journal concerning the National Enquirer and Karen McDougal? Yes. Now, shortly before this article came out, did the Wall Street Journal reporters reach out to you for a comment? Yes. And did you respond to their request for comment? No. Can you read that? An ABC spokesperson declined to comment on Miss McDougal or Miss Clifford. Actually, I think it's a different line. Oh, one moment. Do you see the last two sentences? The last sentence. Yes. All right. Do you see that it says Miss Clifford cut off the contract with the network without telling her story? She didn't respond to requests for comment? Correct. Did that confirm the fact that you declined for comment? Yes. And why didn't you comment for the article? Because I had an NDA. And you were respecting the terms of that NDA? Yes. And was Mr. Trump elected president approximately 4 days after this article came out on November 8th of 2016? Yes. So let me ask you, in 2016 briefly, what was your life like in 2016 to 2017? Yes. So let me ask you, in 2016 briefly, what was your life like in 2016 to 2017? Was ranked 8th in the country. That was a dream of mine. My daughter was a straight A student. I owned a house in Texas with a really wonderful friends. My neighbors in my neighborhood, they had no idea that they lived next door to Stormy Daniels. They just knew I was, objection, Your Honor, overruled. They just knew that they lived next to, I won't say my daughter's name, Mom. And it was really good, actually. And you continue to abide by the non-disclosure agreement? Of course, yes. And you did not say anything publicly about Mr. Trump during that time, right? Right, or privately. Let me direct your attention now to January 10th of 2018. Did you come to learn that the Wall Street Journal was planning to write an article about your experience with Mr. Trump and the $130,000 payment? Yes. And did the Wall Street Journal reach out to you for comment? Yes. And did you comment? No. Why not? Because I was under the NDA. I was respecting that and didn't want to comment. Let me show you what's in evidence as People's 277. Do you recognize that, Miss Daniels? Yes. What is that? It's a statement that was sent to me from Keith Davidson. And Keith Davidson being your lawyer at the time? Yes. And did you sign this statement? Yes. Did you initially want to sign this? No. Were you happy just to stay quiet and not say anything? Objection to the leading. Absolutely. Sustained. Why did you not want to sign it originally? Because it's not true, and because I was told that saying anything at all, anything, was a violation of the NDA. Okay, without disclosing the substance of your conversations with your attorney, Keith Davidson, as a result of his advice, did you agree and sign this, in fact? Yes. You said it was not entirely truthful, is that right? Correct. Now, would you say it's cleverly misleading? Yes. Objection, Your Honor. Sustained. It was not true in several details, is that right? Correct. And in some details, technically? Objection, Your Honor. I didn't hear the question. Was it in some details technically true? Yes. Did you know at the time that Keith Davidson would be getting this statement of yours to Michael Cohen? Yes. Did you know that Michael Cohen would then be sending it to the Wall Street Journal? Not specifically. Okay, did you later learn that when the Wall Street Journal article came out? Yes. Very briefly, what happened to your life when this Wall Street Journal article came out in January withdrawn. When this article came out in January 12th of 2018, did it have an impact on your life? Yes. Briefly, what kind of impact did it have? Chaos. I was front and foremost everywhere. People on the front lawn, my husband asking questions, my friends asking questions, and it blew my cover, I guess, for lack of a better way of explaining it, to everyone that I rode horses with, everyone in my neighborhood, everyone in my daughter's friends. We were ostracized from her play group, from the riding stable, from horse shows. Her dad lost his gig in his band. Objection, Your Honor. Sustained. I'm going to stop you. Thank you. Let me ask you, after the Wall Street Journal article came out, this article, did In Touch publish that article from back in 2011? Yes. That you had given a short interview? Yes. And did you want that article out at that point? No. And that article, when you first gave the interview, were you supposed to have been paid for it? Yes. And did you get paid in 2018 when they released it? No. After this article came out, the In Touch article came out, did Michael Cohen request of your attorney that you go on the Hannity show on Fox? Were you aware of that? Yes. And were you requested to go on Fox and to deny any interactions you had with Mr. Trump? They asked me if I would be willing, yes. And did you agree to do that? No. Why not? Because I didn't want to. Let me direct your attention now to January 30th of 2018. Were you scheduled on that day to go to the Jimmy Kimmel show? Yes. How did that come about? Gina set it up. And what was the plan for what you were going to discuss or not discuss on the show? I was not to discuss the relationship or NDA or anything like that. It was to show that it was to give an example of how I can go on and do promotions and things, but not break the NDA. And what happened shortly before you went on the show? Gina came into my room with some dresses. They were for me to try on to wear on the show, on loan from the designers or whatever. And she came with it was herself, some people I didn't recognize, and Keith Davidson. Do you recognize this? Yes. What is this? What do you recognize it to be? This is a statement that was handed to me in my hotel room when I was in town to do the Jimmy Kimmel show by Keith Davidson. And did you initially say no to signing this? Yes. Without disclosing the substance of your conversations with your attorney, Keith Davidson, as a result of his advice, did you sign it? Yes. How did you sign it? Did you sign it in a particular way? I signed it Stormy Daniels, but I signed it not how my Stormy Daniels signature looks any other time, and I have ever written it. Why did you do that? As a tip-off to Jimmy Kimmel. What kind of a tip-off? That either I didn't sign it, that I didn't sign it willfully. Is that because you were upset about signing it? Yes. And is this statement false? Yes. Now, did there come a time in February of 2018 that you became aware of Michael Cohen making certain public statements about his paying you and objection, leading, sustained? What, if anything, did you become aware of in February of 2018 in terms of public statements made by Michael Cohen about these issues? The articles and the quotes to journalists started to have more details that they wouldn't have gotten unless they got it directly from somebody. And then I found out that Michael Cohen was, objection. I found out that he was shopping a book. Objection to the hearsay. Sustained. Did you believe that some of what Michael Cohen was saying publicly was not truthful? I'm not sure. Well, did you believe that Michael Cohen was making certain assertions about what did or didn't happen between yourself and Mr. Trump? Was he denying that you had an encounter with Mr. Trump? No, he was saying that I did, and he was the fixer. Okay, he was making certain public statements that upset you, is that right? Yes. And why was it upsetting you? Because he could talk about it and I couldn't. Around this time, around February of 2018, did Michael Cohen try to prevent you from coming out and telling the truth about what had occurred? I'm not sure if it was Michael Cohen. Okay, did Michael Cohen file or have lawyers file a temporary restraining order against you in about February of 2018? Yes. And can you just explain what your understanding was of that temporary restraining order? It was to keep me from speaking, or that I could be held accountable for the $1 million that was mentioned in the NDA, or per episode. And following around that time, after you were served, around that time you were served with a temporary restraining order, did you hire another lawyer at this time? Yes. And who did you hire? Michael Avenatti. And did you hire him to try to get out of the NDA at that point? Yes. Why did you want to get out of the NDA at that point? So I could stand up for myself. Now, in about early March of 2018, did Mr. Avenatti file a lawsuit in California against Donald Trump and Michael Cohen's company, Essential Consultants, to try to get you out of the NDA? Yes. After your lawyer, Michael Avenatti, filed that lawsuit to get you out of the NDA, did you also go on 60 Minutes to speak to Anderson Cooper? Yes. Why did you do that? To get my story out. And you did that even though there was a risk that you could be held responsible for a breach of the NDA? Yes. Is it your understanding that by the fall of 2018, Mr. Trump and Michael Cohen agreed not to enforce that NDA that you had signed? Yes. And so was it your understanding that you were then legally free from the NDA so that you could speak publicly and freely about who occurred? Yes. Was it your understanding that the court in California actually found that you were the prevailing party in that suit to free you from the NDA and therefore awarded you legal fees? Yes. And were those legal fees, did they total approximately a little under $100,000? Yes, just under $100,000. And after you were free from that NDA as a result of what we just discussed, did you publish a book? Yes. What was the name of that book? Full Disclosure. And what is that book about? It's mostly about my life. It starts when I'm 2 years old, actually all the way up until, I think it ends in June of 2018. And did you include in the book some descriptions of what happened with Mr. Trump? Yes. Did you include in that book every detail of what occurred in that room with Mr. Trump in his hotel, Harrah's? Not every detail, no. Does the book also include some difficult experience that you had as a child? Yes. And did you disclose in that book for your first time publicly some of the details of what happened to you as a child? Yes. Was the book edited to some degree? Yes. Who edited it? Two people. The person who helped me write it and edit it for spelling and grammar, and fact-checking was Kevin O'Leary, who was hired by the publisher. He mostly transcribed everything I wrote and did some editing. And then I found out later that Michael Avenatti did some editing as well. And did you earn some money from the publishing of that book? Yes. And that was your hard work in writing that book on objection, Your Honor? Sustained. Was it your work on that book that you were paid for? Yes. And aside from making money and publishing that book, were there other reasons as well that you wrote that book? Yes. And what were those reasons, generally? So that my daughter would have an account from her mom's own words of what I had been through and from the various aspects of your life, right? And the reasons why I did the things that I did. Now, did there come a time in April of 2018 that your then lawyer, Michael Avenatti, also filed a defamation case on your behalf against Donald Trump? Yes. Did you want him to do that? No. Why did you not want him to do that? Objection. Overruled. You can answer. It just seemed really risky, and it didn't seem like something that could be won. It seemed like a bad choice, not worth it, I guess. Was the basis of the defamation claim about what happened? Yeah. In a parking lot? Before you answer, just wait a minute. Was the basis of the defamation claim withdrawn? In April of 2018, did Mr. Avenatti release a sketch of the man you believe you had that encounter with in 2011? Yes. And in response to that sketch, did Mr. Trump tweet that the sketch was essentially a con job? Yes. And to your understanding, was that defamation case filed based only on that tweet about whether the sketch was a con job? Yes, it was about the tweet. Did the defamation claim have anything to do with whether or not you were paid for the NDA before the election? No. Did the claim of defamation have anything to do with whether or not you had an encounter with Mr. Trump or any other interactions with him? No. What is your understanding about whether the court in that case made a finding with respect to your credibility whatsoever? There was none. Is it your understanding that the court determined in that case that Mr. Trump was free to tweet con job because it was what the court called rhetorical hyperbole? Correct. And is that the reason for something like just an exaggeration? Yes. And as a result of that, the court's finding was that Mr. Trump was entitled to make that tweet. Did the courts in California award Mr. Trump some legal fees? Yes. Just as they had awarded you legal fees earlier, objection to leading, Your Honor, sustained. Is Michael Avenatti still your lawyer? No. Why is he not? Why is he not still your lawyer? Objection, relevance, overruled. You can answer. Because I fired him, and then later he was found guilty of stealing, not just from me, not just from myself, but from several clients, and he was disbarred and is in prison. Was he found guilty in the criminal case in which you testified? Yes. And were you cross-examined in that case? Yes. And as a result, was that he was found guilty? Objection, Your Honor. Sustained. Move to strike that. The answer is stricken. Have you, as a result of the court in the defamation case, awarded Donald Trump some legal fees, and you're being awarded some legal fees in the NDA case? Were some of those offset against each other so that you actually paid off some of those legal fees that the court said you owed Mr. Trump? Objection to leading, Your Honor. I will allow it. You can answer. Yes. And have you paid yet all of the legal fees that the court said you owe Mr. Trump as a result of the defamation case? No. Why not? I'm sorry, what was that? Why haven't you paid those yet? Because I don't have the means to pay that kind of funds, and because I didn't think it was fair. Now, in July of 2023, did Mr. Trump file a proceeding in Florida to recover those additional legal fees? Yes. And do you have a lawyer assisting you with those proceedings? Yes. And is one of those lawyers here in court with you today? Yes. What is your understanding about whether the outcome of this case will have anything to do with the outcome of that proceeding about the legal fees? It won't. So is there any relation whatsoever to your understanding? No? Let me direct your attention now to February of 2021. Did you agree and go on and participate in Michael Cohen's podcast at the time? Yes. Why did you agree to do that? Because I wanted him to apologize to me. And did he apologize to you on that podcast? He did. Was that the first time you had ever spoken to him? Yes. And generally on that podcast, did you discuss a variety of things? Yes. Including your encounters with Mr. Trump? Yes. And did you agree to go on another podcast of Mr. Cohen's in January of 2022? Yes. And generally, why did you go on again? Because we had a good rapport, and this time around he wanted to ask specifics as to the Michael Avenatti case. And is that generally mostly what you discussed on that? On the second podcast, yes. Now, you mentioned earlier that you were featured in a documentary, is that right? Correct? And what was it called? Stormy. And what was it about, generally? The same as the book. It was generally about my life, focusing more on the 2 years of 2018 and 19. Did it also include information about your experience with Mr. Trump? Yes. And were you paid to appear or participate in the documentary? No. While not paid to appear or participate in it, did the production company agree to pay you $125,000 for the licensing rights to your materials and your book? Yes. And how much of that have you been paid so far? $100,000. And is the sum total of the money that you had received or will receive from that documentary? Is that the sum total of the money that you have received or will receive from that documentary? Yes. Now, in addition to the money that you received in connection with that documentary, that meaning the licensing rights, was there another reason that you agreed to do the documentary? Yes. What was that generally? To get the truth out, the same as the book, to have an updated account. Did you first start on the documentary some years ago? Yes, in 2018. And was that well before we gave you a subpoena to testify in this case? Yes. First, I'm going to ask you on March 15th of 2023, did you participate in an interview by Zoom with members of our office? Yes. And we're showing you now what's in evidence as People's Exhibit 408A. What's the date on this? Well, first of all, do you recognize this? Yes. Do you recognize at Real Donald Trump to be Mr. Trump's Truth Social account? Yes. And did you recognize that to be his Truth Social account at the time, which is March of 2023? Yes. What's the date on his Truth Social post? March 15th of 2023. And were you aware of this post when it came out, when Mr. Trump released it? The next morning, yes. Can you read it for us, please? I can see it. I'm good. I did nothing wrong in the horseface case. I see she showed up in New York today trying to drum up some publicity for herself. I haven't seen or spoken to her since I took a picture with her on a golf course in full golf gear, including a hat, close to 18 years ago. She knows nothing about me other than her con man lawyer, Avenatti, and convicted liar and felon jailbird Michael Cohen may have schemed up. Never had an affair with her. Just another false acquisition by a sleazebag. That's a typo, I guess. By sleazebag. Period. Witch hunt! Exclamation point. Who did you understand Mr. Trump to be referring to as horseface and sleazebag in the post? Me. Had he called you horseface publicly before? Yes. And has he also called you sleazebag publicly before? Yes. Has he called you sleazebag since this post? Yes. Is Mr. Trump's statement in this Truth Social post that he hasn't seen or spoken to you since he took the picture with you on the golf course, is that true or false? False. Why is it false? Because I met with him numerous times after that and spoke to him on the phone countless times. So in other words, the times that you described here? Shaking head. In his hotel room the next day at Trump Tower at the Les Deux in LA, and this is an LA hotel, in addition to objection to leading, Your Honor. Yes, sustained. Your Honor, may we approach for a moment? Sure. Whereupon the following proceeding were held at sidebar. I just want to be inordinately careful. I'm about to ask what the effect, if any, it had on her. You previously ruled that we are allowed to elicit information from subjects from the truths or tweets. What is the answer you expect? It was frightening for her, and she didn't feel good about it, and I'm sure it had a chilling effect. Is that it? Or is she going to talk about threats made to her or things like that? I'll ask generally what effect it had on her, seeing this. Judge, we can't unring it if she comes out and says that. I agree. I think given the discussion we had earlier, I think it's best to stay away from that. Will do. That's why I asked to approach. Thank you. Thank you, Your Honor. I have no further questions. Thank you. Your witness. Thank you. You may inquire. Thank you, Your Honor. And now we will start cross-examination, everyone. Just finished direct, so that was the end of direct for Ms. Stormy Daniels. Next, we will move to cross. Now, I will be getting through just the beginning part of cross-examination. I should be able to make it through her first day of testimony. She did testify for 2 days. She was cross-examined the next day as well. I will not be able to make it all the way that far, but we should be able to get into a good portion of her cross tonight. I will be turning comments on after I have finished reading so we can do a Q&A. So here we go, everyone. Cross-examination by Ms. Necklace. Good afternoon, Ms. Daniels. My name is Susan Necklace. You and I have never spoken before, right? Correct. And I represent President Trump. So even though we've never spoken, you've met with the prosecutors on a number of occasions, right? Correct. And you rehearsed your testimony here, right? No. Well, according to you, the prosecutors subjected you to several grueling prep sessions, which included brutal mock cross-examinations, correct? Yes. And you say that that's not rehearsing your testimony? It is not rehearsing my testimony, but you pretended to be cross-examined, right? My testimony was not rehearsed. That was not my question. Do you want me to repeat my question? Yes, please. Okay, you pretended to be cross-examined, didn't you? No. Well, when you said that just now, you agreed that you were subjected to grueling prep sessions, which included brutal mock cross-examination. Mock cross-examination means that they had someone who pretended to be cross-examining you, right? Objection, Your Honor. Overruled. You can answer. There were a lot of parts. Which part would you like me to answer first? Okay. Is it correct that you had mock cross-examination done? I was asked questions as they would perhaps be asked by the court, but you said on a previous occasion that you had mock cross-examination done to you. I used the wrong word. Mock is not the correct term now that I'm in court. So when you said that before, you were not being truthful? I was incorrect. I did not know what true court would be like. But they asked you questions as if you're being cross-examined, right? Not exactly, no. And you said brutal sessions, right? Grueling sessions, right? True. And they were pushing you, right? The memories were hard to bring up. Yes, they were painful. And they wanted to make sure that when you came into court, you were able to present a good appearance, right? That I wouldn't be too upset. And that you would be ready for cross-exam, right? No, I don't think so. Okay, so when you said mock cross-examinations, it wasn't to get you ready for cross-exam? No response. Right. Is that what you're saying? It was to have all of the facts. They wanted to ask to have as much information as possible. And the prosecutors began your direct testimony today by asking you why you started acting in adult films, right? Do you remember that happening this morning? They asked me why. Yes. I don't think they asked me why. Well, do you recall testifying that you started acting in adult films because you wanted to make more money, right? Correct. And it's that simple. You wanted more money, right? Don't we all want to make more money in our jobs? And that's why you started acting in adult films, right? To get paid, to get a pay increase for my dancing? Yes. That motivates you a lot in life, making more money, right? Well, it is the United States. That's what we do here. Shrugs. Am I correct that you hate President Trump? Yes. And you want him to go to jail, right? I want him to be held accountable. You want him to go to jail, am I correct? If he's found guilty, absolutely. And you tweeted in the past that I won't walk, I'll dance down the street when he's selected to go to jail, correct? Can you show me that's exactly what I said? That's not. Can you please pull up J2 right now, only for the witness and the parties, please? Is that your tweet? Uh-huh. Did you just laugh? Selected is in quotes because I'm quoting something that someone else had said because I knew that you don't get selected to go to jail. You just laughed about that, right? Objection. It is a typo. Overruled. And that's why it's funny. You don't get selected to go to jail. It's not because you think this is all funny. No, absolutely not. When you say so, and that in fact is what you tweeted, right? Yes, I'm quoting another tweet. You are quoting the word selected, right? Correct. And everything else is your words, right? Correct. Your words, I won't walk, I'll dance down the street when he's, quote, selected, end quote, to go to jail. Correct. And part of the reason you hate him is because he won a legal case against you and you owe him today over $500,000, right? He didn't win the case. He won attorney's fees because I was not allowed to go to trial. Court, sorry. You're suing him for defamation, right? Yes. But your lawsuit was dismissed by the court, federal court in California, right? Right. So it was not lost, it was dismissed. It was dismissed. That means he won the case, right? He was prevailed, but I was not found to have lost. So the prevailing part is the winning, right? Right. So you agree with me. He won the case and he was awarded over $500,000 in legal fees, right? Correct. In fact, there were 3 awards for legal fees on his part. Oop, puzzle piece, everybody. Hold on one moment. Yikes. Sorry, everybody. I had to confirm I was live. Oh, my gosh. One moment, please. And we're good to go. Correct. First, on December 11th of 2018, you were ordered to pay $293,052.33, correct? I'm not sure of the exact dates. Can I show you what's been marked as Exhibit J4? Okay. If you look in the top, you'll see, I see it. You recognize that to be the order, correct? Yes, ma'am. I just wasn't sure of the exact date. I offer that into evidence. Objection. Sustained. That was from October 15th, right? I'm not sure. Well, you see the date on it. It says December. I'm sorry, J4, correct. Occurred on December 11th, correct? Correct. And then you appealed that order and lost, right? Correct. And then you had to pay attorney's fees for the appeal, right? Correct. And that occurred on March 30th of 2022, correct? I don't know the date. Okay, can we show her what's been marked as defendant's J5? That was March 30th of 2022. Yes, ma'am. And on that date, you were ordered to pay an additional $245,209.67 to President Trump, right? Sorry. It says it's not on this page. Can you turn to the last paragraph for the witness, please? Page 10. Yes, ma'am. Yet you appealed again, right? Correct. And you lost that again, right? Correct. And you were ordered on April 4th of 2023 to pay an additional $121,972.56, correct? Same. Could you please show it to me? Sure. Can we show the witness and the parties what's been marked as Defendant's Exhibit J6? Correct? Yes, ma'am. That was on April 4th of 2023. Correct. So total, because of your frivolous litigation against President Trump, objection, sustained. Because of your cases that you brought that were dismissed against President Trump, courts have awarded President Trump over $660,000 in attorney's fees, correct? Roughly, yes. And then you testified that was set aside offset by $100,000 in attorney's fees? Yes. In a different case? Nods yes. So the total amount in attorney's fees alone was approximately $560,000 that you owed to President Trump, right? About. And that's before interest, right? I would assume, yes. And in California, has 10% annual interest on this, right? I did not know. And some of these have been pending since 2018, correct? Correct. And you testified on direct. You were asked as a result of the offset, you paid some of the legal fees, right? Correct. But you didn't pay anything out of pocket, did you? No response. Did you take any money out of pocket and pay it to Donald Trump, did you? Object to defense counsel's voice. Sustained. Please allow her to answer. Sorry, can I hear the question again? Sure. Did you take any money out of your pocket and pay President Trump, did you? No. In fact, you've not taken one penny out of your pocket to pay these awards, right? Right. And you said on direct it's because you can't afford it, right? Right. But you have money, right? We all have money. It's because you're choosing not to pay him one penny, President Trump, right? We all have, I don't understand the question. Well, you've chosen to disobey the court order, right? I have chosen not to make a payment while it's still pending, yes. You have announced publicly that you will never pay President Trump the money that you owe him, right? Right. In fact, the day after Federal Court of Appeals orders you to pay President Trump $245,000, you tweeted, "I will go to jail before I pay a penny," correct? Correct. And I show you what's been marked as Exhibit J7. You recognize that as your tweet? Yep. I offered into evidence. Objection sustained. Prior evidence applies. Approach. She admitted each of these. She admitted it. It's not coming in as prior inconsistent statements alone. It's not coming in as that. It's prior evidence of bias, which is admissible to show bias and motive. You're excluded any evidence to be admitted by them on cross. No, that's not correct. I'll allow it. Thank you. Accepted into evidence. We can show that. Is this your Twitter handle? Yes. At Stormy Daniels? Yes. And that was your tweet on March 21st of 2022, right? Correct. And that was right when the Court of Appeals had ordered you to pay money, right? Roughly, yes. And that was you saying, "I don't care about a federal court order," right? That is me saying I will not pay for telling the truth. Well, it was a federal court order. You understood, right? Objection, asked and answered. Overruled, you can answer. That's not what I was responding to. Well, my motivation was because I was telling the truth. Miss Daniels, you understand that there's no question standing, right? Objection, sustained. You're correct. Can you ask the witness to respond? Sure. Please wait until there's a question and then you can answer the question. Okay. But you don't care about the court order, do you? Of course I care. So even though there are 3 court orders ordering you to pay President Trump, you're not going to do that, right? I don't know. Well, isn't it correct? Well, let me show you what's been marked as J1 for the witness and the parties. Do you recognize that? Yep. As a tweet by you? Yep. I offer that into evidence, Your Honor. Accept it into evidence. We can show it to everybody. Again, that's you, your tweet, right? Correct. And it's you again saying, "I don't know him anything, and I'll never give that orange bleep a dime," right? Correct. And that's you calling President Trump names, right? In retaliation for what he said to me, yes. And that's you making fun of how he looks, right? Correct. So when you were asked on your direct examination if he called you horseface, you called him names all the time, right? Yes. Do you despise him and you made fun of him for how he looks, right? Because he made fun of me first. So one of you started it, but you both continue it, right? Correct. But in any case, you also have vowed you will never give him a dime, right? Objection, asked and answered. Sustained. To be clear, at the time that you made this tweet, there were already 3 federal court orders. Objection. Or 2 ordering you to pay money, right? Sustained. Now, you know that debtors are required to fill out a form under penalty of perjury disclosing their accounts, right? Yes. You testified on the record that there's a case in Florida against you by Donald Trump trying to collect money, right? Yes. And you're required to fill out that form, right? Yes. And you have totally refused to fill out that form for ages, correct? False. Well, am I correct that you gave an interview with Jeff Toobin where you said you're not going to fill out that form? It has been filled out, to my knowledge. You'll have to ask my attorney. Did you understand the question? She answered the question. She did. Did you give an interview to Jeff Toobin where you said you're not going to fill out the form? I didn't. Why don't you start again? Thank you. Do you recall giving an interview to Jeff Toobin where you said you will not fill out that form? Yes. And your lawyer was asking you to fill out the form and you said, I'm fully prepared to go to jail before doing this, right? Correct. They were asking for questions about my daughter on that form. Well, the form asked your daughter's name in one place, right? Yes. But other than that, the form is entirely only about your assets, right? I don't remember. My attorney sent it to me. Okay, well, now you say you filled out the form, right? Filled out parts of it. My attorney did it for me. Let me show you what's been marked as J10A. Do you recognize that as the form? It was an email from my attorney, so I think so. I'm not sure. We can turn to the next page. And if we show you page 3 of that, you can see that a fact and information sheet for you. Yes, I offer this into evidence. Objection, sustained. This has my address. Well, let me ask you, you only partially filled this form out, right? Objection, sustained. Can I approach? That's got my address. We are getting way down the road now in that case. Now I understand they opened the door on bias concerning the legal fees, and there's been a lot of testimony elicited. But at this point, this is entirely collateral. I agree. I allowed you to introduce 1 or 2 pieces of evidence that really are collateral. I allowed you to introduce them. I don't see why you need this. I don't need to put it in. I just want to question her about it. She lied about her assets and is trying to hide her assets. Okay? That's all I wanted the document for. She turned to me. She looked very fearful and she said, that's got my address. You asked to approach and she said, that's got my address. She is very much afraid of this form. Ask the questions you want to ask her. I would block off the address. I can appreciate that. We don't need to put that in. I want to ask her about lying about the form. You can ask her, sure. Miss Daniels, if you could turn your attention, if we could show the witness. The parties. Well, just to be clear, this is a facts information sheet having to do with you, correct? Yes. Judge, may we approach? Take that down, please. Whereupon the following proceedings were held at sidebar. You're not offering that into evidence. It's being shown to the parties because she's very much afraid of your client seeing that address. That's what I was communicating to you before. Why don't you just ask her questions about the form? I was going to turn to a different page. I wanted to ask her and wanted to see. She says she's got no money in her bank account. Why don't you ask her first? This is an unsigned form. I don't know what we're asking about. There's no signature on this form. She's not entitled to ask her about a form that's got information that's not signed by anybody. Has this form been filed? Her lawyer sent it to President Trump's lawyer. You can look at it. It got filed with the court. It doesn't get filed, is my understanding. It's not signed. Can I see the form? Yes. It's entirely unsigned. This is the entire form? Yes. At least that's the entire form I received. Where is it signed? It's not signed. It's not signed. I was going to ask her. She's been delaying. She won't fill out the form for 3 years, 4 years. And she said, no, I had it filled out. That was her testimony. Here's what we can do. You can hand it to her instead of putting it up. You can just ask her questions, and you can redirect and ask her if this form is signed or not. Her lawyer sent it to Donald Trump's lawyer. I understand her concerns. That's why you can question her. It's a concern he'll know her address. It was sent to her. I'm not going to get into this discussion. You can hand this up to the witness. Are you handing that up to the witness? Yes, thank you, Your Honor. Whew. Spicy. I'm handing you up what's been marked as Defense 7J 10A. That's the document we've been talking about, right? Yes. That's the document you said you testified that you had filled out, right? Objection. I don't believe that was the testimony. Sustained. You said it was no longer true that you were refusing to fill out this form, right? Yes. So this form has been partially filled out, right? Correct. And if we turn to page 3, it asks about your spouse's income, right? Yes. And you say that's unknown, right? Objection. Reading from a document. I'm sorry. Objection. What's the objection? It's not in evidence. Sustained. I have not heard of the reading from a document objection before. I'm just making sure I'm in frame, everyone. Well, when you filled out this form, you did not give your spouse's income, right? I won't fill out information that endangers my family or my daughter, no matter what. I'm asking about your spouse's income, right? Right. And you did not fill out your spouse's income, right? Right. It asks what care you own or what cars you own or are buying, right? Objection. Sustained. You also refuse to give that information, right? That's whereupon the witness reviews the documents. Oh, actually that was on there. So yeah. And you said you have no bank accounts, right? Objection. That was not the testimony. Why don't you just ask her? Does she have bank accounts? Do you have bank accounts? Yes. Did you tell that on the form that you're required to fill out, disclosing that information? I didn't fill out this form. You didn't fill it out? You're still refusing to provide that information, aren't you? Objection. Sustained. Well, have you provided the information you're required under law to provide so that President Trump can collect on the judgments from you? Objection, Your Honor. Sustained. And you refuse to sign the form as well, right? Objection. Overruled. You can answer. I have not filled out. I haven't been given the form to sign. It went to my attorney. He's not returned it to me to sign. Didn't you testify a few minutes ago? Oops, sorry, everybody. Whoop. It went to my attorney. He has not returned it to me to sign. Didn't you testify a few minutes ago that it came to your email? From my attorney. He's not filled it out. And now you, in fact, own a home, don't you? No, I do not. Well, isn't it a fact that in 2022 you tweeted that you had earned so much money making adult films that you had just paid for your new ranch home? I did tweet that, but I didn't own a home. I do not own a home. So when you tweeted that, that was false. We did not end up buying that house. And am I correct that at the time you said you made $1 million in a book deal and in the surreal life, and that you're just doing the same job you've always done and love doing, and that you just paid for your new ranch home? I would have to see the tweet. Okay, we can pull up J17. Isn't that correct? You said you just made $1 million. I said I've made $1 million. And you said, I just paid. You said, I just paid for my new ranch, right? Yes. And that was on December 11th of 2022, right? Yes. So was that a lie? I pay rent at a ranch. I didn't say I purchased it. Is that what you meant when you tweeted to the world that you had just paid for your new ranch, that you were paying rent? Yes. With $1 million? Nods yes. Isn't it true that you've been hiding your assets because you don't want to pay the judgment against you? No. Didn't you set up a trust in the name of your daughter? Nope. And isn't it true that you're hoping that if Donald Trump is convicted that you'll never have to pay him the more than $500,000 you owe him? I hope I don't have to pay him no matter what happens. Now, while you've been refusing to pay President Trump the money that you owe him, you've also been making money by claiming that you had relations with President Trump, right? Are you talking about the book? Yes. And you've been making money by claiming you had relations with Donald Trump for more than a decade, right? I have not been paid for interviews in the United States, if that's what you mean. Well, that was not my question. My question was, you've been making money by claiming to have had relations with President Trump for more than a decade, right? I have been making money by telling my story about what happened to me. And that story, in essence, is that you say you had relations with President Trump, right? Yes. And that story has made you a lot of money, right? It's also cost me a lot of money. Now, just going back, isn't it a fact that before you started making money off of claiming that you had relations, you were denying that you had had relations with President Trump, right? Because of the NDA, yes. The NDA was signed in 2016, right? Yes. Isn't it a fact that in 2011 you spoke with a prominent lawyer named Gloria Allred about whether you could sue President Trump for money, right? I don't remember what was talked about in the conversation, but I also told her that I had had relations with Donald Trump. You claim you told her that you had had relations with Donald Trump. Is that what you're saying? Yes. Do you remember writing a book called Full Disclosure? Yes. I show you what's been marked as Exhibit J11. You recognize that this is the book that you wrote? Yes. It's called Full Disclosure, correct? Yes. Your Honor, if we could just put that into evidence, just a picture of the cover, not the book. I'll allow it. We can show that to everybody. That's the cover of the book you wrote, right? Yes. And you stated in this book that Gina Rodriguez arranged a phone call between you and Gloria to tell your story, right? Correct. Who is Gina Rodriguez? She's a talent manager. She was someone who helped you on several occasions to sell your story, right? Correct. In 2011, she arranged for you to speak with Gloria Allred, right? Yes. Who's Gloria Allred? She's an attorney. She's a prominent attorney who represented lots of women who have made money from men by threatening to sue them, right? Objection. Overruled. Is that correct? Yes. I actually turned down her offer. Okay, and is this in fact you told Gloria you had a phone call with Gloria Allred? Correct. You described to Gloria your story about President Trump, right? Yes. And you told Gloria that you did not have relations with President Trump, didn't you? No, I did not say that. I told her that I did. I want to direct your attention to page 194 of Exhibit J11G, which will show just to the parties and the witness. Okay. If we could blow that up for the witness. You see that? You can read it to yourself, where it starts off with, I barreled. Am I correct that you had a conversation and you said in a prior statement that you gave Gloria an extremely abbreviated version of your interactions, leaving out relations, right? Yes, during the phone conversation, when I met her in person, I told her everything. All right, I'm talking about when you wrote your book. This is your book, right? Objection, overruled. This is your book, right? Yes. And in your book, you said you left out relations and anything in the least bit interesting, right? Yes. And then Miss Allred asked you, is there anything else, right? No response. Right? Yes. And you said no, right? Right. And then she said, well, I can't do anything else for you if that's all there is, right? Correct. And you said you wrote, I hung up and that was that, right? Correct. I did not tell her all of the relations details. I did not trust her. And she wanted me to accuse him of acts. And so I did not continue that conversation. None of that's in your book, is it? No. Right? You're making this up as you sit there, right? No. Well, you wrote a whole book and you specifically described that encounter and you didn't say anything like you just said, right? Which is why I said it's an abbreviated version of my interactions, leaving out the relations part. I'm pretty sure that backs up my story. You said it's an abbreviated version of your interaction with Donald Trump, right? Abbreviated means I left out some of the details, including the relations, because she wanted to force me into saying things that were not true. Meaning you didn't tell Gloria anything about the relations, right? Objection sustained. You learned from that, did you not? That the story about President Trump that doesn't include relations will make you no money, right? It taught me that I should tell the truth and not trust people, and I didn't feel like I could trust, and she was one of them. In other words, it taught you that if you want to make money off President Trump, you better talk about relations, right? No. Although it does seem to be the case, exactly. So the next time you tried to sell your story about President Trump, you did in fact change your story and say you had relations, right? I don't know what time you're talking about. Well, in 2011, you tried to sell In Touch magazine a story about you having relations with President Trump, right? The first time I told the story about having relations with Mr. Donald Trump was in 2007, so there wasn't a next time. Well, your conversation with Gloria was in 2011, right? Right, it was in the fall of 2011. In Touch was in the spring of 2011. When was your baby born? What was that? When was your baby born? Objection! Overruled. Just tell us the year. 2010. And when you described that interaction with Gloria in your book, you said it was right after the baby was born, right? She was an infant. And in fact, your conversation, you had a series of phone conversations with a reporter named Jordy McGraw from In Touch magazine, right? Right? And she taped your conversations, right? I don't know. And later in a transcript, or it was published, right? It was published. I don't know if she had records of the conversation or not, or if she just takes notes. In 2011, when you had those conversations, you were trying to sell your story, correct? About President Trump, right? Which conversation? Well, the conversation you had with this reporter from In Touch magazine, right? Yes. And you were offered $15,000 to be paid when the story ran, right? Correct. And am I correct that when Michael Cohen threatened to sue the magazine if the story would run? That's what I was told. At the same time, I don't know. At the same time, you told In Touch magazine that you had relations with President Trump. You had your lawyer, Keith Davidson, tell a website that you'd never had relations with Donald Trump, right? I had him send them a notice to take down what they had written. And you denied having had relations with President Trump, right? Right, because I was afraid. Well, on the one hand, you're telling the story to In Touch magazine that you've had relations, and at the same time, you're telling E! magazine or another website that you never had relations with him, right? It was not the same time. The website came after I was threatened in a parking lot. You sure? No response. You sure about that? Yeah. They ran in a couple of times, I think. I'm not sure. It was not until I was afraid. Shrugs. And am I correct what you made a statement in 2011 to E! Online where you said that to E! News that the story about you having relations in your word was baloney. I never gave a statement to E! I was asked what I thought about all this stuff, and I said I thought it was baloney. Well, you said the story was baloney, right? Yes, but I did not refer to the act, the fact that there was a story and that they were trying to publicize it and put it on all of those gossip sites was and still is baloney. So you're saying now that it's not a denial? No. You're saying it was baloney and that it was not going to be reported. Is that what you're saying? Yes. And that's at the same time that you're trying to make $15,000 off of the story? No response. Is that correct? Yes. And isn't it a fact that when you said that what you said depended on who would pay you money? No. Well, one place you say, I didn't have relations. The other place you say, I did have relations. And it depends on who's paying me, right? Objection, Your Honor. Overruled. False. I did 60 Minutes with Anderson Cooper, and they gave me 0. We'll get back to that. I'm back in 2011, right? You understand that, right? Yes. And Anderson Cooper's in 2018, right? Yes. So in 2011, I'll repeat my question. One place won't pay you money. You said you didn't have relations with President Trump. Another place that's offering you $15,000. You gave an extensive interview saying that you did have relations with President Trump. It was a 15-minute interview, and it was the only one I did, and I turned down all of the other ones for money. But the answer to my question is yes, isn't it? No, it's not. And when you say it was a 15-minute interview, it was a 22-page article, wasn't it? Yes. And that's 22 pages of transcript, right? I don't know. And you're a fast speaker, but you think you speak that fast that you could generate 22 pages of transcript in 15 minutes? Objection sustained. I don't know. And you, in fact, never received that $15,000, correct? That was because, as you said, President Trump said your story was false and Michael Cohen threatened to sue, right? I don't know the exact reason why. It did not run. I know that. And you claim that in 2011, after you sold your story to In Touch, you were approached by a man in a car. By what? A man in a car. Yes. And according to you, this man threatened you and your infant daughter. Correct. He threatened your lives, you said. He implied it, yes. In 2011, when this supposedly happened, you didn't tell anybody about this supposed threat to yourself and your baby daughter. I told my close friends. Well, according to you, that threat happened while you were on your way to exercise class. Correct. And right after it happened, you say you actually went to that exercise class. I didn't go to the class. I went to the restroom in the class. You went to the restroom after you went to the class, right? No, I did not return to exercise class. I waited until they were done with class. But you did not tell anybody at the class. You didn't tell your instructor that you had just supposedly been threatened. No, I lied to her and told her that my baby had a blowout in her diaper, and that was why I was crying in the bathroom. You didn't tell anybody else in the class about it? No, they left before I came out of the bathroom. Anyway, you never before this instance said you were crying about it, did you? That was the first time you ever said that. No, it's not. 1 minute. Isn't it true that you wrote about this in your book, right? Yes. And you said you were right. You went right to the bathroom and you must have looked crazy to the instructor yelled at you. Are you okay? Right? Correct. And you said you responded, she had a blowout. I'll be there in a minute. I was afraid to tell anyone. I was alone in the bathroom. I held my baby closely, instinctively, covering her head as I stared at myself in the mirror. You were shaking still, but less now, correct? Correct. You didn't say I was lying and the instructor saw me crying, did you? Yes, I did. I said she had a blowout and that was a lie, and that was not telling the truth. Then, in fact, in the same book, you said I went and did the class, told no one what happened in the parking lot, right? Yes, I went to the class afterwards. Everybody was gone. I told my instructor that she had an accident, and that was it. When you wrote, I went and did the class, you didn't mean to say, I did the exercise class? It was incorrect. I did not do the class. So you wrote in a book saying that you did the class, and now you're saying you didn't do the class. I did not do the class. There's no way I could have possibly done exercises as scared as I was. In any case, you didn't tell anybody in the class about it, right? No, but I wasn't close with those women anyway. You didn't call the police, did you? No. You didn't even tell your husband, who was the father of the child who you claimed was threatened, right? Correct. The first time you publicly told this story was about a supposed threat to your life was in 2018, right? I don't remember. Well, it was on the Anderson Cooper show, wasn't it? Publicly in like an interview? Yes. I know I had told it before because a colleague told it in an interview she did about me. She was the only person that I had called that day or the next day after it had happened. All right, everybody, I apologize. I have to stop here. I thought I could get to their next break, but I'm noticing it's probably another 10 pages down the road, so I'm not going to be able to make it to their next break. Oh my goodness. So let me go ahead and turn on comments, everybody, so we can do a little Q&A. But that's it for the reading for tonight. We almost made it 150 pages, more like 140. So I thought that was pretty good anyway. So let me go ahead and turn comments on here. Okay, hello, everybody. Hello. Welcome. Thanks for joining me tonight. I will make sure to note where we stopped here for the testimony. Hello, 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 everybody. Welcome, welcome, welcome. We'll do a visual here so we have some idea of what's going on. Yes, it's quite the testimony, everybody. I've read through it several times trying to make sure to, make it PG. But it really is quite the testimony that she has to share with us. Love your reading. Oh, thank you, Debbie. I appreciate that. Thank you. Yes. Oh, thank you. Thank you so much. I did great. Oh, thanks. Well, this attorney is very aggressive on cross, which you need to be. But the fact that she's saying at the end of every sentence, right or correct, that's how you lead. That's a leading question. But she's just very, very aggressive. And yeah, I'm not saying that's right or wrong. I'm just saying it's like a movie script. It kind of is. It kind of feels that way. There's a lot in here, but Stormy is really holding her own. She's really holding her own. She's, this attorney, her job is to, oh, thank you so much. Thank you for that. I appreciate it. Her job is to discredit her, right? To impeach her is what we would call her, discredit her testimony. And that's her job on cross-examination. And she's looking for any kind of mistake or any kind of mix up in her testimony. And that's what she's supposed to do. I agree, Daisy May. Stormy is likable to the jury. Badgering may not bode well. Yes, and from what I've seen reported, actually, from multiple people that are in the room and then reporting later, they felt that that Stormy actually had become a very likable witness, and we were in a situation where they felt that she was kind of being badgered or bullied here. Yeah, she's not on trial. And her credibility, of course, has to be questioned. And this whole situation is, really, really awful. But again, the defense strategy here is to say that the situation didn't occur at all, rather than kind of owning it and moving on. They're trying to say, well, no, it didn't happen. It didn't happen at all. And so, that's really putting the state in a position where they're like, look, people, she's giving you the information. She's giving you the information. Object to the leading questions. Great question, Michelle. Now, leading questions are permitted on cross-examination. That is actually part of cross-examination. On the direct examination of Ms. Daniels, there were a ton of leading questions, and the judge said, of course, that was allowable because he felt the state was really kind of trying to keep her within a very narrow parameter. So those leading questions on direct were technically not allowable, but on cross-examination, absolutely. Absolutely. Yep. I don't think they did anything good for Trump here. I'm not sure either. And we still have more. We still even have more. And it's just on it. She just continues on just trying to find any little thing that she can say, well, that's not true. Or is it true then? Is it true now? Which is a classic technique. I mean, it's classic. It's textbook cross-examination. But it's also like you've got to form your cross to fit your witness. And I don't feel like that's really meshing here. I don't feel like this cross is working on this witness, that there was a different technique. You got to kind of go down a different road when it's not working. So, and just from reading it, I'm getting that feeling. But of course, I'm not in the room. I'm not there. This is just my personal thoughts on it. Yeah, it's more, but it continues to be very very, very interesting. All of her testimony is interesting. And then we also have redirect as well. So we do have, one more day of Stormy's testimony. Feels like the details bad. Yeah, bad technique. Exactly, Fountain. I feel like the technique, works, but it doesn't work for everybody. You cannot just do the same thing for every single witness. You really have to be able to be quick on your feet. And if your normal technique's not working, you got to shift it. You have to have a few more in your back pocket and use those to figure out what's going on. We've got a very, not necessarily aggressive, but a very solid, a very unmoving witness here. And if you've got an unmoving witness, you can't just come in with baseball bat. You need to be more precise about it. And she's just hammering away these questions over and over and over again. She's not getting anywhere, but she's still hammering away, as opposed to being more precise with specific questions that she could have asked. Who does right. Hated when she kept saying she was peddling. Oh yeah, that was, and the peddling the story, that was Mr. Blanche that was saying that during the arguments for the mistrial. Yeah. Do you think they'll call Michael Cohen? I do. I think we will see Michael Cohen. I'm betting. We've got 2 witnesses they said that they have left. And I'm not sure which order it will be in exactly. We've got some questions, but I do believe Mr. Cohen will be called in. Absolutely. He again really is the one that is the only one that can really speak to the agreement, because Wesselberg is in prison, although there's some question about, I thought he would have been good to pull as a witness to connect the dots, but of course we've got some trustworthiness here issues with his testimony. Monday for Michael. Okay, on Monday. Okay. So, whoa, yeah, that'll be very interesting, because he'll be a couple of days. I wouldn't think he would be less than that. He'll definitely be a couple of days of testimony, but he's the one that literally had the documents in his hand. So I think that that's going to be very, very important. Yep, Monday. Wow, Monday is going to be really yikes. They stayed away. Yeah, he's definitely moving back with his public statements about the trial. And, I've kind of peeked in here and there, and I've not seen him actually talking about the trial. So we will see how that goes. Defense is going to crush him. Perhaps. But you have to keep in mind, too, everyone, that the cross-examination has to be within the scope of direct. That means the cross can only ask questions that have already been addressed on the direct examination. So if the state is extremely careful with how they ask their questions and they keep the direct very, very narrow, then cross won't actually be able to extend it too much farther. That's why there's an objection called outside of the scope of direct, and you can object saying your cross-examination question was not something that was raised on direct, and so therefore you can't ask it. So if you're really careful, you have to be extremely strategic, and I'm thinking the state has probably been working for quite a while to figure out exactly how to do that. So I think that will definitely be one of their techniques. Yeah, made a request to Cohen to curb his conversation. Yes, and I think that was appropriate. Yes. So yeah, you can't ask questions outside the scope of direct examination. And that was what some of these objections were as well, especially the objection as to evidence, what evidence you can bring in on cross, and those kinds of things. So is that where open the door comes from? Absolutely, Mako, you got it. So there's lots of different ways that we call things opening the door, like opening the door to character evidence, testimony, or if the prosecutor opens the door during direct, then you can go in during your cross-examination. We also have another phrase, if the defendant opens the door too. So we use that meaning that if the door is closed, you can't go through it. So that is very frequently used quite a bit. Professional assessment of the state's skill when applying technique. I think that they're doing quite well, actually. I think that they're very polished. All of their attorneys seem very polished, and I base that off of how they're arguing their objections. Also, even just listening to the arguments that they're having in the mistrial hearings, any of their sidebar discussions, that's for me where I am assessing their polish. Because, you can go in and you can ask your questions and they're going to work or they're not going to work. But to see how attorneys are handling these, immediate questions up on sidebar, that to me is where it's showing their polish. So I really, oh my goodness, thank you so much. Oh, that's so sweet. So I feel the state is very polished. I feel like defense has potential. I feel like they're not really fully. I feel like the defense are off of the tracks, like they're not on the right tracks. And because of that, they can't get full momentum going. Like for some reason, they're not truly catching the purpose and the whole point the true issue going on in the case. Like they've not really grabbed onto that, and because of that, they can't really gain going forward as much as they've needed to. Will harm the prosecution? I don't think so. I think if we just talk about it, I don't think it'll be harmful. You talk about it. You just put it out there and say, hey, what's going on? Why are you doing these TikToks? What do you talk about on your TikToks? What are you doing that for? What's your motive? What's your intent behind that? Let's talk about it and, get it out in front of the jury. So it's not a big secret, just take it out and look at it, smack it around a little bit and, see how the jury decides to take it after that. Thanks so much. Oh, yes, for the gifts. Oh, I'm so thankful. I am incredibly thankful. Seems odd that they didn't object. Yeah, I thought that, Miss Necklace had actually a really good point. She had said the reason I didn't object was because I thought these questions were allowable, that you were allowing these questions. I thought that was a great point, but also showing me like, well, how many times do you go to trial, ma'am? Because even if you think that you're not going to be allowed or that you're objecting too much, you still go up and you knock it down. You still object. And if that judge gets mad at you for objecting, you keep objecting because it's not even about the judge. It's about your record. And so she's like, I didn't want to object because I thought you said it was okay. I'm like, well, hold on a minute. I get it. But, what about your record? You got to keep your record clean. So thank you for your time. Oh, absolutely, Navy vet. Always good to see you. Always good. So I thought that was interesting how she phrased that. I'm not, again, though, it has a lot to do with jurisdictions. Our jurisdictions are very different. Maybe in New York, something bad happens to you if you keep pushing. In my jurisdiction, you just get a dirty look and, you just keep moving forward. Yes, falsifying documents. Yep, it is. Of course it is. Stormy needs to GoFundMe. Oh, I know, right? I know. Yes, so, yeah, I mean, it's a felony. I mean, you can go for up to 4 years for that. It's a lot. And lots of documents, too. So the defense wasn't. And then the judge, yeah, I know. The judge was frustrated. And it's extremely rare for a judge to step in. It happens. Don't get me wrong. It happens. But it's rare. It's rare for a judge to come in and be like, that's enough, or move on. Without movement from the defense, because it's the defense job. Like the court can't do the defense job for them. And, even at the beginning when he was going through the proceedings, he's like, look, if I'll address this, but defense has to bring it up first. How much money has Cohen made on TikTok? Oh, probably not. I can't imagine it's very much. We're very thankful for the gifts, everyone, but it really, you're not going to make that much money in an hour in his show. I can't imagine that he's making a lot. Are all of his attorneys inexperienced? I'm not sure I'm not sure. It just seems like, too, you got to keep in mind criminal defense work, like, I don't know. Let me pause for a minute. He's got a former prosecutor, a federal attorney. So he's got a lot of the background. So he's got some of that, but there's something not quite clicking with Mr. Blanche. I feel like there's something not quite there. And then I don't know anything about this attorney, but she's a New York attorney. So I'm not sure what her deal is. And then there's one more attorney too, the little dude, and I can't remember his name, but I don't know. I mean, I think they're just doing what they think is the best strategy for them. And, we can see on the outside, both. Thank you. Both. Yep. Both. And so, we can see from the outside, like, wow, I don't think it's working. But for them, they're in the thick of it. They're not seeing anything. So for them, they might be like, yeah, we nailed it. Woohoo. But, who knows? They send some big gifts, some of the biggest you've seen. True. Yeah. I mean, but still, I mean, you're not, I don't know. I mean, I guess I'm thinking like how much is a lot is what I'm wondering. Like he's not making, big bucks is what I'm saying. I mean, he's not like hitting 20 grand a month or something like that. I just don't. Yeah, they take 60%. They take a little bit. Actually, I think they take more than that, come to think of it, even on the big gifts. So, I mean, when I'm thinking about it, I'm thinking he's just not making a huge amount of money. He's making plenty. Yeah, not hundreds of thousands. Right. That's what I'm saying. Right. Right. They do take a lot. So, yeah, that's a lot. But the thing is, even if cuz he's on for an hour and if he's constantly getting gifts for that hour, I'm just thinking like if you crunch the numbers, like he's not making, as much as a whole bunch. It's not he's not getting rich off of this. His books, his podcasts, but mostly it's his books. That's where the money is coming in for him, is what I'm trying to say. I think it's a respectable side gig, but not one that's going to be able to like pay his rent in New York. Right. That yeah, it's the books that are making the money. I mean, I don't. Right. And he has merch. Right. Yeah, I think it's really a combo, definitely. Soft advertising for his books. And that's, I think, exactly right. Because it may not be that, he's actually literally making money during the lives, but he is publicizing himself and his, all of the other places that he goes. He goes on all different kinds of stuff and his podcast and his books. So it's advertising for him. So it's not necessarily that like, wow, he made 10 grand in one night. That I don't even see how that'd be possible to make that much money in one night on TikTok gifts. I seriously just don't. And I mean, I just don't. But I think it's helping him sell everything else. I don't want to say it's like for his brand because, that's painful for all of us. But yeah, he's selling his brand. Oh my gosh. Oh, absolutely. Absolutely. I know it's interesting, right? It is interesting. This whole thing is very interesting, and even just reading through the transcripts, it's an interesting story, and it's a tale as old as time. Everyone, you meet a lovely adult actress on a golf course. You have some questionable situations occur, and then you try to make it so she doesn't say anything when you're running for president. A tale as old as time. Oh my goodness. Okay, $10,000 is okay. Yeah, that's a lot. That's a lot, right? That's what I'm saying. Yeah, you know what I'm saying. Right. Adult film star girl meets old dude on a golf course. Oh my gosh. I don't know. I just, I can't say enough, though, that the more I read her answers and the more I read about how she is holding herself in court, like at any point, she could have lost her temper and snapped back and started really going after the defense counsel, and that would have made her look really, really bad. But she didn't. She kept her composure. I thought that was great. It really sparked I'm so glad Bruce Wayne's mother. If anyone should have it, it should be Bruce Wayne's mother for sure. Absolutely. I think it's okay to be, to be interested in this whole area. I think part of our problem is that it's been like shrouded in difficult words to understand and weird procedures and like technicalities. So I think the more you dig into it, the more interesting it can be for sure. She did really well. I thought she did. I've had people, oh my gosh, I've had witnesses that have just like, I even stopped asking questions of one particular witness. It was my star witness. I just stopped and I was like, we have nothing further. I was like, this is bad. This is so bad. Really, really, some battles. Okay, I don't know anything about the battles, everybody. I don't know much about that. It's so intriguing. Well, I think it's just I have a different way of looking at it, because I don't see why it can't be more interesting. Now, I don't know. We're going to get into the whether or not she can talk to ghosts bit coming up. So I don't want to spoil that yet. So I wouldn't spoil that yet. Books for aspiring law students. I'm not sure, everyone. That's a tough question. Of course, I have to say my very favorite book that inspired me to become an attorney was To Kill a Mockingbird. So that was really it for me. Cosplayers. Oh, really interesting. But there are lots of amazing, books out there with lots of that. But trials about, yeah, voter interference. Yeah, exactly. It certainly is. Maybe add an Amazon list. Oh, that's a great idea. Oh, I should do that. Oh, that's a great idea. I'm going to do that. You figured that due to my cat's names. Yes. Yes, Atticus is curled up right now on his little bench over there. Yes, the client was excellent. Yeah, the client was excellent, of course. Yeah, the John Grisham's, got a really interesting take on that. So, 12 Angry Men. Oh, okay. Yeah, very interesting. I think anything that just gets you wanting to change something. Whatever inspires you to be a part of change, I think, is a great book for going into law school, because you have to really hold on to that. You have to keep that and hold on to the flame and to get you through the tough times, for sure. Prosecutor will present evidence showing. I'm not sure. I think we have to be careful about any kind of evidence about misstatements and untruths. We have very specific rules about that. So we've got to have certain kinds of evidence that are offered in first. The door has to be open. I guess that would be a great time to use that phrase. Will he testify? Yeah, I don't know. I wouldn't imagine it. If he's not dealing with a self-defense issue, I would not imagine this would be helpful. The Boy Called It. Oh, that whole series. Absolutely. A Boy Called It is, oh my gosh, even to this day haunts me. And absolutely. And that was a book that absolutely inspired me when I did a lot of the juvenile work I did. So how do you think the trial's going for Trump? I would say the trial is going, I think the trial's going great as far as how you would want a trial to go. Like, there haven't been any big hits. They haven't taken any huge hits. And so if they just stay the course, I think they're doing good work. Now, does that mean they're going to win? I have no idea. Again, 50-50 when you're in front of a jury. Doesn't matter how good your evidence is. 50-50 shot. But I don't think that there has been anything that's, there's not been like any sucker punches, where you're like, ooh, that one was bad. That's what you want to hear. We still have 2 witnesses left. So we still have that potential to, still get a black eye. We just don't want that. But I think so far, I think that the path that the prosecution has taken has been pretty good. I think their timing has been good. Their questions have been well done, polished. Their arguments at the bench have been pretty good as well. So I think they're doing pretty good. But of course, we still have to see the defense side. Technically, they don't have to put a defense on. But, I will be very interested to see what the defense is going to do. It's sounding like they're definitely wanting to dig into this NDA issue. So I think that'll be a huge part of what they put on for their evidence. I'm not sure the jury's gonna go down that road with them. Honestly, I'm just not sure that's gonna happen. It could, but so yeah, it seems like that. It seems like forever. Where do you find these sketches? Oh, they're all online. They're all online by some wonderful artists. I'm very thankful for all of their hard work. Yeah, accountability, everybody. Accountability, and I've said it before, it's a slow process. It takes a while, and it looks different for every single person. So it just takes a while for it to come down. So yes. Well, we've still got lots of cases running at this point. We still got a lot going on. We still have a lot going on. I am planning to do an overview of the Florida case as well. I'm very interested to see when the interlocutory appeal gets set. So the longer accountability takes it. Yeah. I would say anytime you've got money, the process is going to be much different than if you don't have money. I think that's just the truth. That's just facts. That's just how it is. But we do try to equal it out as best as we can. Love learning. Oh, thanks, Blue. Appreciate that. Yes. Oh, you're welcome, Amber. You're welcome. Yes, and I do need to, I should be pretty much caught up on my Tube of You. I've got the David Pecker transcripts that I have read. So I've only read through the Pecker transcripts and then Miss Daniels. So that's been it. Oh, and Hope Hicks. Oh, I might need to get Hope's up. I have 2 days of Hope Hicks's that I need to post. So in the next few days, I'm hoping to have all of the transcripts up and running. So that's the I'm doing it as quick as, yeah, I saw he lost his appeal Bannon. Yeah, interesting. I will get those up as quick as I can, everybody. I try to post, be able to post about every 6 hours or so to YouTube, but hoping to have those up as quick as I can. Yes. So I will. How many printers have I gone through? Well, my printers work hard, everybody. I had both of them running tonight, and my cats just sit next to the printers, and they're just like, I'm not sure. Oh, thanks for all your hard work. Oh, absolutely. 2 of you just went up about it. Okay, excellent. Thank you. Yeah, I'm trying to time them out as best as I can here, but again, I'm just like a one woman show with a whole bunch of wonderful moderators and tons of support. So, oh, my moderators are the most amazing ever. Yes, before Judge Mershon. Yep. So with that, everyone, I will go ahead and sign off for tonight. Now, I will need to take a break tomorrow. I can tell already I've got to rest my voice for at least a day. I will be back for sure for my sub chat Sunday. Absolutely back for that. And I will kind of give you a better idea. We do still need to finish up Stormy's testimony. And then, of course, we've got lots of other testimonies. So lots and lots of things to continue to cover. So thank you all for joining me tonight, though. I really appreciate it. And to all of my moderators, you are amazing. I'm so grateful for your time and effort and support. So I will be back very soon, everybody. I will make sure to, do I have a Cohen voice? I'll have to work on it. I don't know. I've tried to work on a New York accent, but I haven't found one that's not offensive. I don't want to be offensive. Oh, thank you so much. So I'll work on it, everybody. But have a wonderful night, and I will be back for my sub chat Sunday, everyone. So take care.